The defense has offered you significant money to go ahead and settle your accident case or your medical malpractice case. But you'd rather roll the dice and see what's behind door number 2 rather than take their offer. You want to learn what this is all about and whether or not you should really do that? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So now you've brought a case, whether it's an accident case or a medical malpractice case, and now during the course of the litigation, finally the defense turns around and makes you a substantial offer. And you say, you know what? I'm rejecting your offer. I want to roll the dice and see what the jury does. And then I'll take what's behind door number 2. You know, just like in The Price is Right, I'll take behind what's door number 2. Well, guess what? Whatever's behind door number 2 may not be nearly as much as what's being offered to you right now. The problem is you don't know what's behind door number 2. You don't know what a jury is ultimately going to decide in your particular case. You may think you have a great valid case. You may think that the injuries are so substantial that they're worth an astronomical amount of compensation. The jury may disagree. The jury may agree. The jury may give you more. The jury may give you less. And it's possible the jury could give you nothing. And you may think, wait a second, I have great liability. I can show that the other person was careless. I can show that that carelessness was a cause of my injuries. And now I know I have very significant injuries that are lifelong and permanent. There's no way that the jury could give me 0. Well, let me share something with you. The jury could give you 0. You know why? Because they might find that the other person wasn't careless. They may find that you contributed to your injuries. They may find that there's no connection between the wrongdoing and the injuries that you suffered. If that happens, you get nothing. If you can't show that you're more likely right than wrong, that the other person was careless, then you get nothing. If you can't show that the carelessness was a cause of your injuries, you get nothing. And now the jury will have to evaluate if they find that you are more likely right than wrong, and you can show that there was carelessness and that the carelessness was a cause of your injuries. Well, guess what? They may find that your injuries are not worth what you think they're worth. So why do I share this great information with you? I share it with you to give you an insight and an understanding to what goes on in the negotiation process in a car accident case, in a medical malpractice case, and even in a wrongful death case. You know, chances are you're watching this video because you have questions or concerns about your own particular matter. Well, if your matter happened here in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. You know, I can answer your questions. This is something I do every single day. I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.